And welcome back, everybody, to another. Actually, hold on a second. Let me stop that. That's not.
Already stopped.
And welcome back, everybody, to another Not Guilty. It's your boy Davey D here, bringing you the freshest Not Guilties across these United States. What's up, America? Are you ready for a fight? Because we got one here. Let's go. I don't
That was
know
hot.
what. Is that hot?
That was hot. You did it.
Of course, that's my awesome co-host Lauren Marie Manning from the Los Angeles Public Defenders. What's up, Lauren?
Hi, guys. I'm excited about this. I've had a little bit of a break, but I'm back.
Yeah, you did have a little bit of a break.
Mhm.
I don't know about you, but I woke up Monday morning exhausted. And it's only Wednesday right now.
I mean, there's a lot happening right now.
We are under siege. We are recording from a bunker here in Los Angeles.
Hiding out from the National Guard.
Yeah, that's right. Speaking truth to power against the powerful government. Let's go.
True.
That's what public defenders are about.
Let's play it.
The media, they're making whatever. This is just called Tuesday in our world.
So. Just another day in our life.
Another day, we've been saying for like years, a threat to justice anywhere is a threat to justice everywhere. We've been just hollering those things from the criminal justice world for like decades now. So
we've been sounding the alarm. They've been calling us Chicken Little. The sky is falling, but now it actually is.
So it's all across America, from California, from all the way to the great Sunshine State of Florida. I know they're doing the fight over there as well, because we are awesome guest today, premier defense attorney, all the way from the state of Florida. We have Andrew Darling with us today. Andrew, go ahead and introduce yourself to the A&G universe.
Hey, what's going on, A&Gers, guys? Thank you so much for having me. I am a criminal defense attorney here in Orlando, Florida. I spent the first 9 or 10 months of my life as a public defender down here in Orange County, and then back right before COVID, started my own firm. And we have 3 associates now and 7 or 8 employees. I can't remember. It's a lot.
You're not still a public defender.
No, I sometimes wish I was.
Well, obviously, yeah.
Once I kind of branched out after COVID, it just never went back.
It's okay. You're 9 months in. We'll take it. Not quite a year, but we'll take all we can get. That's for sure.
I will say we did try to bomb the docket when I was at the PD's office with all the trials, and I only got 2 trials in 9 months.
Oh, okay.
I mean, that's because probably they were scared to see you coming. They were settling them, right? That's the power of the public defender.
Yeah.
Why don't you tell people why you left the PD's office? Like, what happened?
Yeah, so I was actually running to be the sheriff in Orange County. I have no prior law enforcement experience.
What is happening right now?
Orange County, Florida, guys. Orange
County, Florida. I had no prior law enforcement experience, and I believe the place that you change the system is law enforcement. Because by the time it gets to us as PDs or us as defense attorneys, it's too late. I don't care how progressive your prosecutor is or how empathetic a judge is on appeal. None of that matters if you fix policing. And that was my thought process. It was an entire criminal justice reform ticket. And I came in 2nd out of 5, so I was the first loser.
Wow, okay.
Okay, so not only are you not a public defender, but you also ran to be the sheriff. We're really taking this podcast in another direction today. I'm excited to hear what you have to tell us. Oh boy.
I ran to be in charge of the deputy sheriffs, not to be a law enforcement officer.
The elected sheriff, Lauren.
Yes.
I'm clear. It's not usually what happens on this podcast. So
I will say that one of the best things that happened to me was that I didn't become the sheriff.
Yeah.
Again, obviously. Yeah.
So a lot of it is because it wouldn't have given me the opportunity, obviously, to do the work that I've done to get the not guilty in the case that we're here to talk about today, and several other cases that we've been able to get them. But a lot of it is the type of institutional problems that law enforcement has and has had for many years. I don't know that I would have been able to fix that. And I would have probably been miserable for at least 4 years.
So what I'm hearing you say is that your training as a public defender allowed you to secure this victory as a private attorney when you realize that if you have the best public defender around, the best lawyers around who are always public defenders, it's not too late.
100%. And I will tell you this too. Whenever I speak to potential clients, I am one of those private attorneys that I tell them public defenders are phenomenal attorneys. I know here in Orange County, the caseloads can be ridiculous, particularly for felony cases. And the thing that you are hiring a private attorney for is you're hiring us for our time. That's what you're hiring us for. And the skill level, like there are public defenders that I know right now in here in Orlando, in Orange County, and Osceola County. They're better lawyers than I am. I'll tell them that to the face. I tell them that in front of my clients.
Recognize.
But the clients are paying for my time, and that's the thing that I have to give them.
All right. Okay. So
I can't wait to hear this. Let's get into it.
All right. So let's tell us about one of those clients that had your time. Let's share with the A&G universe what you're able to do when you got some resources. Andrew, it's great to have you on the podcast. Thanks for coming on. Looking forward to hearing this one. Andrew and I have been kind of back and forth trying to get going for since July of last year, or it's been like 6 months or 10 months. Like we almost recorded a couple times. It didn't happen. So I'm glad you're finally here. Glad we're finally able to listen to this story. So Andrew, tell us about this not guilty all the way from Orange County, Florida. What was your client charged with?
Yeah, so my client was charged with second-degree murder as a principal, which has the same ramifications as just being kind of by yourself. Basically, as a principal is you knew about some sort of plan, you encouraged or participated in that plan, and she was arrested for first-degree murder, charged with second-degree murder, and then after 21 months or 652 days in custody, we had a jury trial and there was an outcome.
All right. Well, listen, so just back to the charge. Arrested for first degree murder, but charged for second degree murder as a principal, meaning they were part of the plan in committing the murder. So then what's the, as opposed to what? A principal as opposed to what? A bystander, or just kind of,
or the actual killer?
Like what?
Initially, the state could not figure out which of the two people. So it was my client and a co-defendant, both women, girlfriends at the time, and the state really could not tell who killed this gentleman. So they kind of went forward on both cases with both co-defendants. The co-defendant recently took a plea for 10 years.
Well, let's kind of stay where we're at. Okay, so you could be charged for murder as a principal or just murder.
Yes.
As a principal as the
okay. Yeah. So generally, if you're just charged with murder, like you are the principal. So the principal theory is essentially you were there, you knew of the process, you didn't do anything to stop it, but it's more of you actively participated is what the principal instructions are. So you are as responsible as, it's similar in some states have like felony murder. It's kind of the same thought process. We don't,
or aiding and abetting.
Yeah, it's more of a, you were there, you were a part of the process that led to the death.
Yeah, so we call it a major participant, right? So in California, you can be the actual killer, you can be a major participant, or you can be someone who was acting with, reckless disregard for human life. But we say you're a major participant even if you weren't the actual killer. And it sounds like that's what you're saying.
Yeah, that sounds similar.
Okay. All right. And what did your client allegedly do? What's the state claiming? What's their theory of the case?
Yeah. So the state's theory is there was a disagreement between this gentleman and my client and the co-defendant at the largest bus station here in Orlando. There was a disagreement, some kind of argument. The gentleman walks away. My client and the co-defendant walk another direction. They see the gentleman walking. They follow him. And the state's version is they were stalking him, following him. They had planned to do something to him after the first interaction. And, a couple blocks down the road, which is, again, all out in public, and most of which is caught on the city's security cameras. They say at some point, he ends up being shot in the back and being killed.
This is a stranger to your client and her girlfriend?
To my client, yes. Sort of a mushy gray area on how much of a stranger that person is to the co-defendant, which is kind of an interesting part of the story too.
Okay, and we'll get into that in a second. So the state's theory is your client is at the bus stop with her girlfriend. The stranger approaches. They have some type of verbal altercation. The stranger walks away. Client and girlfriend follow him several blocks and then get into an altercation then with him, and then and that's how they
Yeah.
kill him.
Yep.
Did you say how he was killed? Was he shot?
Yeah.
Was he stabbed?
So both.
Okay.
So he is. They get into a physical altercation, and then they get in the physical altercation, and then at some point he is both stabbed somewhere in the front, like in his lower abdomen area, twice, and he is shot in the back one time.
And are there like witnesses to this? You said there's video, right?
There is city surveillance video from the city of Orlando that there's Lynx, which is the bus company here, Lynx buses. They have the footage from the actual bus depot. It is our downtown, like the main bus station. They have video from there where the first interaction takes place. They have them leaving, and then they are picked up on the city surveillance camera walking. It's roughly 4.5 blocks, but most of it, you can tell they're in the video. Some of the video is kind of far away, so you can't really tell exactly what's happening. But the actual allegations of the murder, the death itself, is on video. It's kind of grainy and like up in the corner of the video, but it's completely on video.
And the video shows the decedent and two people engaging in some sort of squabble.
Yes. So initially, my client and the decedent are fighting, and then you see the co-defendant walk up. When the co-defendant walks up, you then see the gentleman fall, and you can't really see what happens right after that. But then both my client and the co-defendant leave the scene, and there's a sort of a fun way that they're identified later.
Physically fighting?
Yes.
Okay.
Does someone call 911?
Yes. So there was a this takes place across the street from Salvation Army, sort of it's not a homeless shelter, but it is sort of a transition housing for people that are housing unstable, if you will. And then there was some calls from there, and then there was also not a club, but kind of a hangout spot, halfway the other way up the block.
Okay, so there's, several people did kind of call it in and see it. Okay.
What time of day did this happen?
So it's in the evening time. It's I believe it's around 9 o'clock, 10 o'clock at night. It's not.
Okay, so it's dark. It's not like this happened in broad daylight with a bunch of people to be able to see it.
No, it is dark.
Okay.
And then how's your client arrested?
So this
identified.
Happens,
also.
Yeah. So this happens October 9th of 2022. My client wasn't arrested until November 11th, and she was arrested on November 11th. So essentially the case had gone cold in the first month. And what happens is the co-defendant makes an allegation of domestic violence against my client in October 30th. So like right before Halloween. So you figure it's been 21 days since the incident. Law enforcement has no leads. Domestic violence accusation, client gets arrested. Once her picture hits the jail website, those photos,
the stills from the video.
They're public photos. They run every person that gets arrested through their little AI algorithm for their open cases, and she gets matched. And then, oddly enough, co-defendant, her father is the one that identifies them as law enforcement continues to, because the father thought that they were there talking about the domestic violence incident. So investigators showed up with photos from the day of the killing, and they ended up seeing photos from that. He was like, yeah, that's your client. That's my daughter. Of course it is. And
this is why you don't talk to the cops.
Ever.
Especially if you shoot somebody, right? Not even like a month ago.
Maybe you just break up with your girlfriend instead of calling the cops on her.
It would have been easier for everybody involved.
Let's give them names. So we can keep them straight. So your client shall be called.
So my client, I have permission, and all this stuff is available publicly. I do have permission. We can just call her Miss Watson. That's her name.
That's your client?
That's my client, is Miss Watson.
Okay.
And then the co-defendant, Miss Santana. It's public. You'd be able to find this on the Orange County Clerk of Court's website. So it's not.
Okay, so we can call Miss Santana Carla.
No,
like Carlos Santana. Yeah. And what about what is Watson's first name?
Kalani.
Not the real first name.
Yeah.
What should we call her?
Yeah, wait, let's just go. Miss Watson, Miss Santana. We usually go with first
Are
names.
you
for
sure?
this
I
one,
mean,
right?
yeah, normally go first names, just like we try and get away with that in court, try and humanize them.
Okay. So Carla and we said
Kai.
Calanche.
We can say
Kai.
Kai.
Okay, Kai.
Kai.
Okay. Kai and
Okay.
Carla.
Carla and Kai.
And who's
All
the
right, so Carla's dad identifies the two of them, believing he's helping in the investigation of his daughter being the victim of domestic violence. But the police pulled a dirty trick and actually had him identify them from the video stills of the day of the murder.
Yes.
Oh dear.
All right. Well then, so that's the case. And then tell us about like when you received the case. Like where was you weren't the first lawyer on the case, right?
No. So when she was arrested in November, the family did November of 2022. The family did reach out to me. There was some mix up with the family with who was communicating with whom. They ended up hiring another lawyer who does criminal partly, but that's not the main.
Not very well.
It's not the main thing that they do. So I didn't actually get hired until I believe it was February 13th of 2023. So three months ish later, where I get on the case, and then we start an incredibly long process. We begin with depositions. We get all the video. I mean, we're talking hours of video here. I mean, I think we went back through and looked, and there's almost 200 hours of video
Okay.
in this case.
It's just all this different security footage that you had to come through from all the businesses along the walk.
Yes. So there's the bus station has multiple cameras, multiple angles, no audio. It's all video. The city cameras are also all video, no audio. And then there's another couple businesses along the way. There's a hotel. There's a what's the hotel office building? And then there's also a apartment complex building that they walk by. And then there's the Orange County Public Schools building, which is downtown here. That also there's an angle from the parking garage. So there's all these different videos to go through, and it's essentially the entirety of from the first interaction he has with them at the bus station till he's eventually shot is less than 15 minutes.
Okay.
But
that equates to 200 hours
of video. It's absolutely ridiculous.
Does any of the 200 hours show anything stand out to you other than just the 15 minutes, right?
So there's a lot of just the sort of the angle of the walks from the bus station, because I grew up in Orlando, so I know downtown really well. Like this is my home. This is where I'm from. So sort of knowing the path that they walked, knowing where his body was found, knowing where they started, before I even looked at all the video, I thought through what are the ways that you can get to this endpoint. What are the most likely ways? Because they just send you the video. They don't tell you walked up this street, made a right, turned on this street. None of that's in the police report.
Oh, okay.
So they kind of let you guesstimate. So I knew which city cameras to go look at. There's a couple of them that they send us, an hour long piece of video for 12 seconds where they cut by a corner and turn this way. And it's one of those things that there's absolutely no reason to send me that much. If you know where they are in the video, cut it and send us that part. But
right. So, well then, tell us about when you met your client though. What was that like?
So the only other trouble she'd ever been in was the domestic violence from a couple weeks prior, which ended up getting dismissed because there was no domestic violence. But she was not in a good space mentally.
Okay.
Obviously, she knew about what situation we were talking about. They actually, both my client and the co-defendant, ended up going in and doing full interviews with law enforcement, which were not good.
Yeah.
So they were problematic because they put themselves at the scene.
Well, yeah, just tell us what your client said. How did your client say it to law enforcement?
Yeah, client said they were sitting at the bus station. This man walked up.
I just have a question before you give that. They gave statements separately or together?
Separately.
Okay.
So they were split up. They were arrested at different times. So my client was arrested first, And then when they ended up arresting the co-defendant, she ended up having another long story. Majority of the story is consistent. So we're sitting at a bus stop. Man approaches, says some offensive things, something to the effect of, dirty pigs or something. It was this gentleman. We believe he was unhoused. We're pretty certain he was unhoused. So just the interaction was weird from the get go. My client and her girlfriend had just arrived at the bus station not too long before. They had went out to eat, so they were finishing some of their leftovers, and our anticipation was they were just waiting on another bus to go home. And then he comes up and says something. As he walks away, he leaves going around one part of the building. Co-defendant says something to my client, which we learned later was that's the same guy that tried to take me, or that's the same guy that tried to rape me on a bus a couple weeks prior.
This is the statement your client's giving? So she tells the police that her girlfriend says that guy tried to rape her on a bus a couple of weeks ago.
Yes. So
Okay.
what she says is when they got up and they were walking, they didn't know exactly which way he went. They knew he went around one side of the building.
Mm-hmm.
But then when they started walking, they saw him again. So what she said was she wanted to confront him and basically just tell him like, hey, that's unacceptable. That's not okay. Like we're not going to do things like that. And my client, about 5'8", 125, 130, maybe on a good day. The gentleman was still a grown man. He was about 200 pounds. I think he was 5'9", 5'8", 5'9" himself. But like at the end of the day, it's probably not a smart decision if you're 120 something pounds to go fight somebody that's 200 pounds. But it wasn't even necessarily that the intention was to go fight.
Right? Well, Andrew, it seems like there were a lot of bad decisions made to go and confront this guy, not just the size differential there. It seems like...
Yes. So yeah. Client sees the gentleman walking, and then my client is walking, crosses the street, is walking after him. Co-defendant is following my client. My client, you can tell they actually go under a bridge, which is Interstate 4 here in Orlando. They go under the interstate. All of this on camera. You see some kind of altercation between my client and the gentleman. It's some kind of physical tussle. The video is just not clear enough to know how much they're fighting.
But wait, how does the altercation? You said that the girlfriend wanted to confront him about what happened because he tried to rape her.
No, didn't you say Kai wanted to confront him? It wasn't Carla. Yeah. Carla says to Kai, that guy used to tried to rape me, and your client Kai is like, all right, I'm gonna go talk to him. I'm gonna have some words with this unhoused gentleman who's already tried to be violent.
So then, what did Kai say about the confrontation?
What's her statement?
Did he tap? Was he facing the other way? She tapped him on the shoulder, like he turns around. Like what happened?
They were yelling, and you can see in the video, like through the body language, that she's very clearly yelling to like get his attention. You see in the video he stops at one point and sort of turns around, and there's some type of dust up initially, and then he walks away. So
dust up meaning verbal?
No,
What's
there was some kind of physical.
Okay.
So you can't really see in the video how physical it gets, but there's some type of physical.
Okay.
What
does your client say though?
So I feel like we keep jumping back and forth between her statement and the video. Just what was her statement that she gave to the police?
Yeah, her statement to the police was that they were arguing back and forth the entire way, and that eventually they get into a fight. So this part is not really part of her statement, but this is sort of as you're following the walk.
Right, but I want to know what her statement is. Her statement says she goes to confront this guy. Does she start? She says they're arguing back and forth. Does she say she starts the argument? What does she say that she said to this guy? How does it happen according to her?
Yeah, so she says at some point they get to where the actual death occurs. She doesn't talk about any physical confrontations really in between or on the walk, if you will. But she talks about the last altercation where they're arguing and he turns around and squares up and she squares up with him and they start to fight. And she very quickly gets the sort of losing end of that altercation.
Shockingly.
As he pins her up against a red Nissan Murano, and he has his arm, what she says in the video, in her statement, is He had his arm across my neck. I was starting to lose consciousness. I did not know what was happening, and then he fell. That's what her statement is in the sort of arrest.
Yes.
So
interview.
her statement is that essentially she gets up to follow him, to confront him, and that their only altercation was verbal until he turns around and ends up choking her. So she never cops to any sort of physical violence that she's perpetrated in her statement.
No,
Correct?
she says like when he turned around, we squared up and we were ready to fight. So she was like there ready to fight, and I think like as they come together, she's trying to hit him like as they come together, but he just overpowers her and presses her up against the car.
So she admits to trying to start a physical fight then.
Well, she said that they had just been arguing for so long that at some point he turned around and was ready to fight, and then she was also ready to fight. So it's not that she was starting the fight; it's that they kind of agreed to fight after arguing for a couple blocks.
What's
Okay.
the part? What's the part that you don't like about that statement?
I don't like that we followed this gentleman for 4 blocks, because that's the whole purpose of the state's case, is followed the entire time. And the thing that I didn't necessarily mind about it was she is saying we were having an argument and then we agreed to fight, and he turned around to fight me. So like at that point, worst case, it's just a battery. It's just a misdemeanor battery.
Well, it seems like they agreed to fight. She loses the fight, and so he ends up getting shot and killed.
And
Like-
stabbed.
Yeah, like it seems like it's kind of hard to say self-defense when you kind of instigate a fight, right? You can't really claim self-defense. Unless he's about to take it to another level. He was choking her. I mean, so maybe he was trying to kill her. Go ahead.
A lot of a lot of states are very different on sort of what the stand your ground bases are. So in Florida, we have a pretty robust stand your ground.
We're like
It's
you.
very
California's
famous.
like you.
Yes. But part of it is
His name? The who shot the kid with the Skittles? That's how that got famous. George Zimmerman?
George Zimmerman.
George Zimmerman. He made your stand your ground laws pretty famous.
Yeah, for all the wrong reasons.
Yeah.
But we were in a position where we felt like she was charged as a principal, which means it could have either been her or Carla. So what we ended up saying was essentially Carla's the one that was defending Kai. Like that was sort of our position.
So were they tried together?
No. So we were
Okay.
together for a long time.
But
so we
even though they weren't tried together, did you get to use her statement? Because you said they both gave statements.
Yes. So
Okay, so what was
hold on. We're not talking about if it's bifurcated or not, right? So what? Let's just.
I know what her statement is. If he got to use that, so what was her statement? Carla's statement.
Yes. So Carla's statement was that Kai had owned a knife but didn't have it with her that night. That this gentleman had previously tried to take her. At the entire process, she doesn't know how the gentleman died, but that they started fighting and then he fell and they left. It was
So mystery.
I was
The
not supposed
wounds.
to be able to get that in the trial, but I'm sure we'll have a conversation about that soon.
So her statement was, "I don't know. He just died."
Yes.
Essentially.
There was a bullet in him and a stab wound, and we didn't do it or see anything.
It just happened.
And and that my client owned a knife but did not have a knife with her that day.
I own a knife too. It's in the kitchen. So yeah, that makes sense.
God, these are shit statements.
They're very good.
Because also like the fact that they talk about her, Carla being possibly raped by this guy is sort of motive to follow him and confront him and be violent. Like there's just sort of this sort of motive and conspiracy to act together that's kind of brewing right now. So
yeah, and they're not saying that's what was happening that night. He wasn't trying to take her that night.
Right.
This was some revenge.
Yeah, so for us, we were able to keep that out at trial.
Okay. All right, we'll
prior
talk. We're going to talk about
relationship.
that later. We're going to talk about
Yep.
that when we talk about the trial. Okay. All right. So we got. So this is the evidence. You got these shit
Two
statements
statements.
from your client, from Carla and the client. You got video showing an altercation. It just shows an altercation. Shows following something like that. He drops, falls,
Question.
gets a gunshot wound. Go ahead.
You said that the video was grainy, but it actually shows the moment of the murder. Yes?
It does.
Okay.
Homicide.
Sure. Homicide. The moment of the homicide that you can see. Can you talk about what you can see there with your client and Carla Carla, what they're
Yes.
doing?
Yes. So my client does appear to be pressed up against the car. So the
Okay.
gentleman is arms are in front of him. You can't really tell where his arm is. So like I said, my client's statement is that it was across her neck and pressing her up against the vehicle. And you can see Carla walking up. And as soon as she walks up, the gentleman falls. And there's allegations that he was that the gentleman was like kicked or stomped when he was down, but it's just not clear because it's dark in the video. Like you can see the parties move there, and like I don't think there's any dispute about yes, there were 3 people there, but it's
Okay. So you
it looks like a
can't
fight.
see, do you see a flash from a gunshot or anything? No, you can't see the glint of a knife.
Nope.
No. And what you see is at least somewhat consistent with your client's statement in that it does appear that the decedent has your client up against a vehicle. And then he doesn't fall until the co-defendant, the future co-defendant, Carla, walks up to him. And does she walk up to him from behind or the side? How does that happen?
So he is facing the car with my client in front of him, and she comes up from what is his right side to behind him, and there's some movement with her arms, and then a slight pause, and then he drops. And it's not something where like the shot was, according to the medical examiner, almost nearly immediately fatal.
So the coroner said the cause of death was the gunshot, not the stab wound.
Yes.
Okay.
Did the coroner say anything about the stab wounds?
Yes. So there were 2 puncture wounds to his lower abdomen. So one sort of by his hip, and then the other one sort of right below his belly button. And then there was a very weird, incredibly straight cut along like his, it almost looked like a C-section but wider, and it looked like it was a newer cut, but it was just incredibly smooth and consistent of a cut, that it did not look like it was anything that it came from that interaction,
From a struggle.
so yeah, from the struggle. It didn't look like it came from the interaction.
It was clean. It was clean.
Yes.
Happy face.
Yes. So, and again, we'll talk about more of like what we talked about with the medical examiner.
It would have been like a Charlie Brown like this if it was,
yeah,
No,
it was. Again, the photos that we received as part of this case were not for the faint at heart.
So you have 2 statements. You have video. Were there any other witnesses?
There were witnesses who saw the disagreement, but nobody that actually saw a shooting, a stabbing, or anything like that. So there were folks that were there immediately after, when my client and the co-defendant leave the scene, that see him, and law enforcement is there like within 5 minutes.
Who calls 911?
So several people. I think it's 3 or 4 people. Some of the party goers that were up the block. I think there's one unhoused individual from the transition housing.
The home across the street.
The people who call 911 see him on the ground. That's why they call him, but they didn't see the actual incident that led to him being on the ground. Is that right?
No. So 2 people say they heard a single shot and that 2 girls were leaving the scene. Well, they actually said that 1 girl and 1 boy were leaving the scene, because my client's haircut at night could have been interpreted as either a boy or a girl.
Your client's more masculine looking.
Yes.
Let's move it along. So then what any other pieces of evidence we should know about? We got a coroner's report, we got video, we got witness statements, you got statements from the defendant, both defendants. Any other pieces of evidence?
Yes. So there is DNA of the doors of the vehicle. There's fingerprints from throughout the scene, none of which match my client or a co-defendant. There's nothing that physically ties them to the scene.
Fingerprints where? Of what? Fingerprints on the what?
On the car.
But that's just a random car that was right there that they were pressed up against.
Yes, but the state made a big deal about how good the investigation was.
I assume that they had search warrants as well for Carla and Kai's residences. Did they find any weapons?
So for when they were together, they were sort of staying in a van in a carport. Their home situation was rough at the time. So they did have a search warrant for Kai's van that she was living in. They found basically the clothing that was similar to what Kai was wearing that night. They then later executed a search warrant on Carla's parents' home, found Carla's purse. In that purse, there happened to be some rounds of ammunition that were the same brand as the casing from the crime scene.
Trouble.
Yeah, but there's only three brands in the United States. You know, everyone has the same.
But they didn't find a gun or a knife.
Never found gun. Never found a knife.
It's like saying there's a pair of Nikes.
Yeah.
Yeah,
Chuck Taylors, black Chuck Taylors. That's
black
actually that's what the video shows that Kai is wearing is black Chuck Taylors.
All right, Chucks. I mean, so then any other pieces of evidence? Well, is that? I mean, pertinent. I'm sure there's like tons of little stuff. So, what? Let me ask you my question though. So, what? So you get the case. You meet your client Kai. You go through all the video. You see the witness statements. Like, how does the defense take off from there? Like, what are you gonna do to get this not guilty? Like, what are you doing?
Yeah. So our position really early on was I need Carla to file a stand your ground motion. The problem and basically defense of others.
This is co-defendant. So the
Yes.
co-defense. So you need her to file stand your ground. Why?
Because because my client was charged as a principal, if the principal is found to have not been responsible, you can't also be responsible. So for example, if Carla is found that she was defending Kai, because even if Kai consented to a fight, the potential act of her being choked up against a car exceeded her consent of that fight. So now Carla, being also a small, younger female, was unable to physically remove this gentleman. So she did not have a choice but to use force because she thought that Kai was, fear of serious imminent bodily injury or potentially death. So
Might be a dumb question, but why didn't we just say she's just not guilty without stand your ground? Like, her intention was to confront this person. She never had any intention to end his life or do serious bodily harm. She wasn't found with any weapon. She didn't make any statement that she had a weapon. The video doesn't show that she did anything, that the guy didn't fall until Carla comes over. There's no evidence that she worked with Carla for some plan to kill this guy. So why do we even care about all that? So why aren't we just saying she was there but not guilty of any murder or conspiracy to commit murder?
So for us, the reason we wanted the stand your ground to go first is we thought it was appropriate so that we knew where we were positioning wise for a potential plea, that we wanted Carla to go first, basically in the trial posture. The issue that we ran into is I know Carla's attorney. I worked with her throughout this entire process. Phenomenal attorney. Carla just wouldn't agree to ever take ownership of the gun. And to file a stand your ground, you have to put the gun in your own hand. If she's saying she was defending Kai, she had to basically put the gun in her own hand.
Right, but I guess my question is, who cares about her? Like, why was that necessary? Why not just say, Kai's portion of this was I was just trying to confront this guy. I had no intention of killing him or causing great bodily injury. I didn't know what she did. I don't know if it was stand your ground. I don't have any part in that. I'm not guilty of this.
Yeah, so that's what our trial argument ended up being. But at this point in the process, we were still together. We had not
got
the trial.
You were exploring theories because you still had a co-defendant.
Yes.
And trial counsel for Carla would not file the stand your ground motion.
She couldn't get Carla's permission to file the stand your ground motion.
But why? Also, why do you have to file a motion for self? Usually, you just go to trial and you argue self defense. Is there like
This is Florida, David.
declaration that it's going to be self defense, and the judge has to allow before you can even bring self defense to a jury, or what? How does it?
No, so there's a tactical reason for it, and the tactical reason is we had done depositions of, I think we deposed.
Well, you gotta tell us about the depositions then.
16 people, and one of the purposes of a stand your ground is it is kind of a mini trial before the trial, so it was going to give us another run at all the witnesses that they needed to call, and like I said, we had their first.
It's like a hearing. It's a pretrial hearing, is what you're saying.
Yes. So, and if it's granted, what's granted is actual immunity from prosecution. So it's like in self-defense, obviously it's a jury question, right? But here, the stand your ground is an affirmative process where if we allege facts sufficient to show that stand your ground was possible, it shifts the burden to the state to show by clear and convincing evidence that this was not stand your ground.
That it was not made in self-defense.
Yes.
And so you get to have a hearing about this and have all these witnesses testify, but for that to happen, you need co-counsel to file the motion.
Yes.
And co-counsel wouldn't do it because they don't want to give an element to the DA, to the prosecutor. They don't want to even admit your client had a gun because the video doesn't even really show your client having a gun. Mm-hmm. So they're just not quite ready to give that. I guess so, right?
Yeah, so we had gotten to a place.
Wait, you can't take it back? You can't be like, we want the motion. Oh, we don't want the motion anymore. We're changing our strategy, Judge. We decided against it.
They could file it, and then even if they lost, you can still assert stand your ground or self-defense at trial, which are essentially the same thing at trial. You can still use it because the burden is different, right? So clear and convincing, somewhere in that hopefully 75%, even though we're never supposed to use numbers, it's still a much lower burden than beyond a reasonable doubt. So it was a situation where the co-defendant just refused to ever put the gun in her own hand. So we couldn't do that.
But I'm sorry, so you file the stand your ground, that means the co-defendant has now admitted they have the gun in their hand and they can't take that back. And that admission can be used against them in court during the trial. It's like an admission. Do they take a plea, a waiver? You're waiving your right to have this fact presented and to dispute this fact in your upcoming trial. Do you have a right to a trial over this one fact, but you're going to admit it right now? Is that what happens? In
stand your ground, the case law here in Florida is if you are asserting stand your ground, you are admitting to the conduct because you're saying that conduct was lawful, and you don't get to take it back. That's your assertion.
Okay. Is there like a waiver in court that happens, or is it like a declaration that your client's making this waiver? How does that go down?
So we have C4 motions, which are motions to dismiss. The C4 portion is a sworn statement. So most of the time in stand your ground, you're going to have your client, you can have them sign the motion basically as, yes, this is true and accurate to the best of my whatever. But a lot of times they don't. So the thing is, once you file that motion, it is difficult, but it is possible for the court to take notice of the file and determine whether that's relevant evidence or not for a jury to see. They're not supposed to, but I have seen stand your ground motions that get incredibly complicated, and there are admissions in there beyond just I was the shooter.
This is fucking stupid. This is
Florida.
It's a wild place.
It's a trial, self-defense trial. We're putting up witnesses and presenting evidence that was in self-defense. It's a fucking element to the fucking murder charge that it was in self-defense or wasn't in self-defense. We have a whole hearing on whether or not a defense could be presented. Could you imagine if the prosecution's case was this scrutinized? It's never this scrutinized. They just like, oh yeah, go ahead, charge, prosecute, throw it in front of a jury. Well, defense, you want to do something? Hold on, let's take a closer look here what the defense is doing.
I was listening quietly, hoping for it to make better sense, but it just wasn't getting any better.
All right, I mean, California has stand your ground, but we don't fucking go through all these procedural hoops just to get there. We just go in front of the jury. So
the jury instructions, which I'm sure we'll get to at some point, they are helpful in understanding the foolishness that is sort of self-defense as well as a principle argument.
Yeah. But I agree with Lauren. I think at the end of the day, the defense is like, your client's just like, look, hey, I agreed to fight this guy. This guy was like, kicking my ass, and she shot him. I had no idea that she was going to shoot him. Was I getting? I was blacking out because I was being choked. Does that mean it was a reasonable fear? Does that mean that that she thought he was trying to kill me and she was protecting me? I don't know. It just fucking happened.
That's no problem.
I didn't even know there was a gun involved. I mean, like, that's kind of like, I think that's the defense, because I think at the end of the day, like, no jury is going to like the fact that this person they started to fight with this guy, and now this guy is dead, so that's kind of like.
But even in California, you're still allowed to claim self-defense if you started the fight. I mean, there are things you have to prove in between there, but you can still get to self-defense even if you're the one who started the fight.
Yeah, and we were in a position too where I got on this case February of 23. By February of 24, March of 24, we had decided that it was time to sever the cases and just get ready for trial.
Well, let's talk about getting ready for trial. So did you depose any witnesses?
We did. We deposed 15 or 16 witnesses here.
Okay, any good ones?
So the lead detective, it's a scenario where I will say this, as far as detectives that I've interviewed or deposed or anything previously, she was incredibly thorough. The problem that we sort of reached was she sort of picked what the outcome was really, really early on, and the entire investigation was to serve that outcome, which is why they were arrested for first-degree murder.
She led with confirmation bias.
Yes, and
why do you say that? Why do you say she picked this certain outcome? Like, what did she say in the interview?
In the interviews themselves, so when we actually, when you watch the interviews, she's trying to understand basically her version, which is they stalked and killed this man. That's what her sort of version was coming to it. So in the interview, she's trying to figure out why that happened. She never once in her investigation or in the deposition when we're talking about everything, until depositions, does she admit, okay, I guess there are other reasons why something like this could have happened. She knew it was this cold-hearted, premeditated murder, and that's what it was going to be. And every part of the investigation that she did from that point was to serve that purpose.
As soon as she heard that they got up to confront him, that was the end of her.
Yeah, there was one funny officer that we deposed, and I actually the state attorney in this, the prosecutor, we'll talk about him a little bit. But we were in this deposition, and I asked the gentleman, the officer, one of the other like backup detectives, if you will, just one of the people that shows up at the scene, and we're like, all right, did you take any notes? No. All right, so did you get anybody's statement? He's like, no. I was like, so what did you do at the scene? And he's like, well, I was going around and just making sure everybody was in there. So I was like, yeah, but you didn't take any notes. You didn't talk to me. So like, what did you do? And he just couldn't answer. And I was like, and how long were you there? And it was like 2 or 3 hours.
He was collecting his overtime.
And I'm like, did you transport anybody anywhere? Did you find any did you bag any evidence? I was like, what? He was like, no. He was like, I was there to support the lead detective. I was like, how did you support the lead detective? And he's just like, I don't remember. It's been
coffee.
A long time.
I got coffee when he wanted some.
But it was
donuts.
But like I asked him.
I was a Starbucks guy, I brought
towards the end. I asked him, and this, like, I actually made the state attorney laugh when I asked this in the deposition. I was like, all right. I was like, Officer so-and-so. I was like, how many times in a month do you go to a scene for 3 or 4 hours and do absolutely nothing? And he was just like, and like when I asked it, like co-counsel was sitting next to me, and she was like mortified that I would even ask that question. And he was just like, I don't just go places for 3 or 4 hours and not do anything. I was like, okay, so that was just this case. And he's just like, well, I don't remember anything from this case. I'm like, okay, thank you. And the state's like, yeah, I have no questions.
Why was this person deposed? I mean, like,
so they're on not just the state's witness list, but they're also on like the list of people that was present at the scene.
Oh yeah, okay.
And we couldn't find any written anything. So to me, a lot of times that's a red flag for there's a report that we don't have. But then we got there and learned, no, he was just there. That's all. He wasn't doing anything.
It's a funny story, but I do love that you get the chance to ask all the officers questions, because we're not able to do that. mean, I've tried to get creative and send our investigators out to talk to the officers because they're mentioned in the report and they don't talk to us, and we can't, there's nothing we can do to hear from them short of
You guys can't
subpoenaing
even-
them to trial.
You guys can't file a motion for depositions or anything?
There's no criminal depositions.
Yeah, we don't do that.
Wow.
So we can
Unlicensed
subpoena them
individuals.
to court and they can testify in front of a jury, but we have no idea what the hell they're going to say if we don't have a report from them. Yeah.
Yeah, that's rough. So we have them. You can get them in felony all the time, and if you motion for them, you can get them in county court, which is misdemeanor land. So the only real thing that you would normally do in a misdemeanor situation is like domestic violence situations or like DUIs. Like everything else, there's not a lot of depositions in county court.
I mean, I love that you got to embarrass this guy too. That's fun.
That was a long day. That was a good part of the day.
Yeah, just
Was there
taking
any-
a shot.
Was there any like good witness statements that you liked that was favorable for the defense?
Yeah,
Or
there was some,
depositions, I should say, whatever you
Yeah.
want to call them.
yeah, there was some mix up about what the actual brand of casing that was found at the scene. Just between the investigator. Actually, the lead investigator had said that the deceased didn't have any tattoos, but he had a huge tattoo on his chest. So it's like there's little things like that that
Yeah.
are helpful. Like they're not substantively helpful, but they're helpful for the just little cuts, right? Like little
Right.
cuts to the credibility.
Yeah. I mean, it's kind of like this case, the facts aren't too much in dispute. It's all kind of on video. There was an
Mhm.
altercation that led to the shooting. So it's going to come down to like really like your client's state of mind and what the jurors believe. And so I think I cut you off earlier, but you were talking about now it came to the point where you decided to sever the cases, right?
Yes. So because the co-defendant just
Describe
She-
severing the cases to A&G verse. What does that mean?
Yes, so that means that we are filing a motion that basically says it is not possible for our client to get a fair trial if the cases are tried together because either the facts, the theories, everything is so intertwined that the jury, even if we pick two separate juries to sit on the trial together and one evaluates one co-defendant, one evaluates the other, that doesn't change the fact that certain things that are admissible, both juries are going to hear. So certain things that are not admissible or would not be admissible for one person's trial may be admissible to the other person's trial. So, for example, co-defendant's statements in that video should only be admissible at her trial, not at our client's trial. So, even though they were good for us, they shouldn't be admissible at our trial.
Now,
So-
I've done a co-defendant murder trial that was severed, and so we had two juries in the courtroom, and then sometimes the judge would be like, "Okay, jury jury A, step out of the
Yeah.
courtroom because only jury B can see this evidence now." Okay, now jury A come back in. Jury A, jury B, you guys don't talk to each other ever. You know.
Yeah, we know that they never discuss what happened.
Yeah.
No one ever goes, "Hey, what did you guys listen to when we left the room?"
Yeah, while we're back here in the
Yeah.
same room for lunch, nobody's
Yeah.
talking, of course.
Yeah.
Waiting in the hallway for an hour.
Yeah.
Judge is like, jury A, please step out of the courtroom because what the evidence we're about to present is going to be too prejudicial to the
Yeah.
person you're judging.
Yeah.
There's some really bad evidence. We
It's
don't
gonna
want you
be
to see it.
juicy.
I want you guys
Yeah.
to get the step in, all right? And don't even think about it. Don't even
Yeah,
think
so
about it.
once we made the decision to sever, we filed a motion to sever. The state did not object.
Interesting.
Because the co-defendant she never, at this point, I think they'd also sort of raised competency concerns for the
Oh.
co-defendant. So we didn't know if that was going to go we have a separate like competency docket where folks get evaluated for their mental health and whatever. She came back competent at some point.
But
But-
that delays your client from going
Yes.
to trial because once they're deemed not competent, it suspends proceedings.
Right.
But your
Yes.
client's still like, hey, I want to try my case. I have a speedy trial right. I'm not going to wait for my co-defendant to be competent.
So that's
Um,
where we were going into June of last year of 2024, and we were ready for trial. We were there in the morning with the regular sort of trial court judge that we were supposed to have set for 5 days on a Monday morning, and I had just seen my client the night before, going over all the last sort of final minute things, and we get there the next morning, no client. So I go down to give her her clothes so she can wear real clothes instead of her jumpsuit. They're like, yeah, she's not here. I'm like, I'm
Wait.
sorry, she has a murder trial today. We're picking a jury today. And they're like, yeah, she's not here. She refused to come. And I'm like,
Oh, come on.
I'm like, first of all, that's the same excuse you give for everybody. So I don't believe you because I don't think that's the case. I just talked to her last night. So we're up in the courtroom. Judge has his judicial assistant calling the chief judge's judicial assistant, calling the jail, trying to figure out everything. Turns out there was a breakout of COVID in one of the female dorms.
Oh no.
And
So
they
she was in
refused to transport her.
quarantine.
Yeah, they refused to transport her. So we tried this for 2 days. We tried on Monday, couldn't get her. We tried on Tuesday, couldn't get her. Judge is like, listen, I have to move this along. If we can't get her over here, I'm like, Your Honor, like we have a trial set. And then they got into they asked weird questions about sort of the separation of powers between the jail versus the court versus what can the court actually order a jail to do. And the answer is almost nothing,
Yeah,
realistically.
it's like
Yeah, it's almost nothing. So we ended up getting reset for August, and at that point we filed our demand for speedy trial.
well, I don't want to. I mean, I'm not trying to get. Well, I guess I am trying to get into like tit for tat politics, but like Florida really was known for not giving a shit about the pandemic and COVID, and then here we are in 2024, like 4 years later, still like denying people their rights to a jury trial and due process because of a sixth and right to a trial in the Sixth Amendment because of COVID. Like
I had a trial in December of 2020 in Seminole County, Florida, which is the county next to Orange County to the north. In December of 2020, like jurors had on like the clear face shields.
yeah,
Yeah, we remember the shields.
It was the weirdest thing. But
it was.
we got a hung jury on that one, and then they ended up dismissing it. But it was it was a weird process.
So you're looking at now it's August and you're starting a trial. The trial, even though it's been delayed 2 months, you didn't have to revisit severing, did you?
No. So
okay, so it's just Kai.
Yeah.
And then I just want to ask a question before you get into the trial. If we rewind to the beginning of the episode, you said that Carla called the police on your client for domestic violence. And I just wanted to know if there was anything relevant about that or any investigation about that in regards to the murder trial that you did before we start.
We did do a motion to compel to get whatever evidence there were because the case was no information or dismissed prior to charges being filed. And we filed a motion to compel that was heard by the court for the state to give us everything from that interaction. So they had to go back and get the body cams, they had to get the police reports, they had to get everything to give to us from that interaction, but there was nothing there that was particularly relevant for the murder case.
Okay.
All right, so now let's jump to the trial then. I imagine the quarantine ends. Your client can now come to court. So now where are we? Late July? Where are we?
August, I believe it was the 18th is when we started trial.
August 18th.
18th or 19th, yeah.
Okay, and then how are you feeling about your defense at this point? What is your defense? Is it gonna be it was self-defense or defense of third person, or is it gonna be had nothing to do with it? Do you have a decision right now?
So because the way it's charged as a principle is it's essentially, listen, yes, Carla killed this guy. We're not fighting about the facts of the case here. The facts of the case are what they are, but she acted lawfully because she was defending Kai. And because she acted lawfully, Kai didn't do anything wrong. There's nothing that Kai could have done to change the situation at all. So how can she be responsible for Carla's actions? And we also
you're gonna try to tell the jury that the shooting was justified.
You sort of backdoored the stand your ground.
Yes.
Yeah.
And what it is like my client never had a firearm, so I couldn't file a stand your ground and put the firearm in my client's hand.
Mm-hmm.
And the way that physically the bodies were positioned, like for my client, she would have had to have been like one of the Fantastic Four that can stretch his arm all the way around to shoot him in the back. Like there was no way for her to do that. So, I mean, that was our theory of the case, and it was just one of those things that we're not scared of the evidence. One of the things that I said in the beginning is we are not scared of the facts in this case. And
I like it.
The state brought up that you're going to see a bunch of videos and all this other stuff. So I brought up that, yeah, because defense stipulated to them, because we want you to see all of the videos in this case. We want you to know what happened so you can make the right determination.
Okay, all right. So that's the opening statement. Let me ask you this. So right before we start trial now, how is Kai doing? Anyway, she's been in custody for over a year now.
Yes.
What's that like for her?
So she is to a place where she is as comfortable as any client can get in a jail situation without knowing how long I'm going to be here, how long I'm going to be in custody. Um, One thing that did come up last minute right before the trial is the regular trial court judge said because we filed our demand for speedy and that demand ran on a week that he had a bunch of other trials, we were going to have some random judge come down and be the judge for the case, which for me is I've had sort of hit and miss situations like that when you have a trial with a judge you're not familiar with. But we didn't just get a judge, we got a district court of appeals judge that used to be a circuit court judge, which is the felony level cases here. And he came down from the DCA, the District Court of Appeals, to do the trial. So now we have a judge who is thinking about a trial, not just from a trial court's perspective, but from an appellate court perspective.
Mm.
And that comes into play a little bit later, too.
Oh, good.
Did your client want a trial, or was she hoping to settle?
So the state never gave us a formal offer. So they were saying, we wouldn't do anything less than, 12 to 15 years, but she's got to accept that before we formally make the offer. And we got late in the process when we completed depositions, we shared with the state, she will do 5 years on any third degree felony, which is the max, day for day on any third degree felony of your choosing to not go to trial. And they were like, no, we're not even going to entertain it. Okay, we did our part. And that was kind of where she was like, listen, we gave them the opportunity to try to get something. And I made a comment to the prosecutor during that conversation, who's like, 5 years. We're not doing that. I said, okay. I said, you're going to either take 5 years or you're going to get nothing. And I don't normally like make proclamations like that. But at this point, the case had gotten pretty contentious because the prosecutor was just hook, line, and sinker, whatever the detective said. And like, you have to have some sort of independent thought about a case. And the state just refused.
You'd hope they would use their prosecutorial skills to analyze whatever the detective is telling them.
Yes, you would hope.
All right. Tell us about any motions in limine, motions to exclude evidence.
So the state filed a motion in lim to keep out co-defendants' statements, the recorded statement, because it was helpful for us, which we didn't have a legal basis to really argue. So we agreed to that.
Wait, this is Carla's statement? They wanted to keep out. And they wanted to keep out why?
So because it couldn't be, so it's not my client speaking. So basically the same way in Florida, so it's in Florida, if the statement would have been bad for my client, we would have been able to exclude it because it's not the defendant's statements. And she's not going to come in and testify because she's still.
I understand it's hearsay, but what were they worried about with the statement?
Because she says in there that Kai never had a knife on her that night. So even if the state was going to try to argue that my client had a knife and my client is the one that stabbed him, and that led to the rest of the violence, and if you can show that my client stabbed him, I think that would have been a big enough leap for the jury to be like, well, yeah, of course she's equally responsible.
Okay.
And then, so they want to keep that out. I mean, there's really no basis to bring it in. There's no opportunity to cross-examine. Makes sense. So you didn't fight him on that.
No. So we stipulated to 3 main things. We stipulated that all the video can come in. And we did that for a couple reasons. One of the reasons was the witness list and the witnesses that we did depose about who could authenticate certain video. It wasn't super clear exactly which videos they could authenticate because there was one part where like you go by 2 buildings, but you're not entirely sure which camera angle is from which building. So we could have probably figured it out, but to even just save the issue of that, like, let's stipulate to it. Let's get it in. We want the video in anyway. And we also stipulated that the individual who was deceased was that individual because I didn't want his family member to have to come on the Zoom and cry and all this other stuff. And then we also stipulated that, yes, that's him. And yes, he is in fact deceased. So we stipulated to his identity and that he was dead.
Okay. Yeah, that's cool. All right, so tell us about jury selection. What was that like?
Jury selection was so in Florida, a second degree murder is a first degree felony that's punishable by life. So based on the score sheet, the least amount that you're going to score is like 22 years. So if you're convicted, that's the bottom of the guidelines. That's the least that the judge could sentence you to, barring some type of basis for a downward departure. So, but you could also be sentenced up to life. So you get 10 preemptory strikes, and of course, 4 cause challenges and whatnot. I think we had a panel of 60 or 65 jurors that came in. We had 22 cause challenges. So we had a bunch of cause challenges combined between the state and us. And then we had used our 10th preemptory on somebody that we thought was a cause challenge, but for whatever reason, the court didn't grant our cause challenge. And then we got to a place where we were out of preemptories, and we were to literally the 6th person on our jury. So in Florida, you only get 6, generally plus an alternate or 2, depending on how many you have left in the panel. So we were on the back row of the final row of people.
Wait,
And
you only get 6 people on your jury? That's what when you say we only get 6?
yes. So there are, if it's a capital case,
Fucking
then you get
Florida.
12. Yeah, it doesn't matter if it's driving with a suspended license in misdemeanor county court, or if it's second
A murder?
you get 6. So we get
Yes,
to
we
the place
wouldn't
where
want too much thought and discussion going into someone possibly serving life in prison. Got it.
Yeah, heaven forbid lots of
Mhm.
people talk about it. So we get to the 6th person who would be on the jury, and we are out of preemptories. And this person, throughout the process, was kind of just looking. So our client's a black female, the co-defendant's a Hispanic female, and this is an older white lady. And just throughout the process, like, we didn't do much back and forth with her, but she just had it's kind of an edge about the way she looked at our client. And there was something about it that just wasn't right, and it didn't sit well with me. And we got to her, and at that point, the jury is kind of out of the room at that point while we're doing the actual selection part. And at that point, I brought up to the court, I said, Your Honor, I said, I want to go back to this person, and I would like to do a cause challenge. And the state's like, well, we're done with cause challenges. And I was like, I was quiet, because I know that you can do a cause challenge at any point. Like, there is no, even if you're done with your preemptories, like, a cause challenge is a cause challenge. If I didn't bring them up at first, I can bring them up now. So we're talking, and I said, Your Honor, this person was constantly sort of mean mugging, was the way I explained it to the judge. My client, whenever we did have interactions with her, she was very short, just with a response, very matter of fact. When she first came in, like, her first look at my client was just like disdain. And he was like, he's like, Mr. Darling, he's like, I don't think you're wrong. He's like, let's question her real quick. Which is, as an appellate court judge, I think that's the right thing to do. You bring him in, you question. So we asked a couple more questions, and I basically asked, I said, listen, I said, none of this is to make you uncomfortable, but obviously we have to make sure we have the right jury for this process. And I just straight out said, I said, since we've been here, I said, you've been kind of giving my clients some looks that aren't necessarily friendly. Are you able to explain that a little bit? Like, why would you be doing that? And not once did she say, I wasn't doing that, I haven't done it. Her response was, I'm not sure. I'm not sure why I would do that. And at that point, the state was like, yeah, I don't have any questions. So she leaves. We get the cause challenge, which was great, because she was a person that I absolutely did not want on the jury. And the next person was good for us. And then, of course, we ended up with an alternate. We got our jury.
So you got her kicked by the judge for just because she said, like, yeah, I'm not sure why I was giving him bad looks.
I can't even imagine.
Well, in the
my cause challenge, when they say, what's the basis? Well, Your Honor, I didn't really like the way they looked at my client. I can't imagine that working with any judge.
So it wasn't so much that. I think it was really her response. Her response was, it wasn't I didn't do that. I wasn't looking at her that way. It was just kind of like, I don't know. Right? Like, why? I don't know why I was doing it. It wasn't a denial. And it's one of those things where, like, I argued to the court, if she can't even tell you she didn't do that, how is she supposed to be fair and impartial starting here?
I get your argument. I just don't imagine it working with any judge I've done in front of here. It's impressive.
I don't think it works in front of any trial court judge.
Yeah.
So because he was an appellate court judge, I think him knowing what the issues would be going up on appeal, if this were a conviction, and him denying that cause challenge, if that person was on the jury, I think for him, we had enough people left that we were going to be able to get a jury anyway. Now, do I think it would have been different if we were going to bust the panel and have to start over? I don't know. I like to think it wouldn't have been different, but I don't know. But yeah, we got our jury that day, and we had we four men, 2 women. I think 4 of them had advanced degrees. We had an older Black woman. We had a younger Hispanic male. We had a white female, and then we had 2 white males. I believe that's 6.
Anything about the gender? Like you had 4 men. Your client, you said she's only like 120 pounds and trying to fight a grown man who's like 200 pounds. Did that play any role in your choosing of the jurors?
Our bigger overall picture was we need educated jurors. We need people who are like, one of the folks worked at Lockheed Martin. Like one of them was, I'm sure you guys know who Morgan & Morgan is. We had a person who was a paralegal at Morgan & Morgan at the time who wanted to go to law school. So like we had people who were able to think through this. For me, I was less concerned about the makeup of the jury as far as male or female, as I was making sure that people were educated and were going to be able to think through this defense, because this defense is not it sounds simple on that, but you have to understand and be able to read the jury instructions to understand why we went the direction we went.
And I'm sorry, is your client Black? Did I
Yes.
miss this? And the
Yes.
girlfriend's Black?
Hispanic, he said.
Yeah, girlfriend's Hispanic.
And then the deceased is
Also Hispanic.
Okay. All right. So let's talk about opening statements then. How'd that go?
Yeah. So the state got up there and had one of the most confusing PowerPoints, because there's all the different angles of the videos from the bus station. And it was like a PowerPoint with different colored arrows pointing in like the direction of the video. And it was like, all right, this is an okay start for us. Like we're okay here.
Mm-hmm.
And then doesn't talk about the entirety of the interaction is 14 minutes. He makes it feel like it's this long, drawn out dispute that our clients are just stalking this guy forever. And it's just not that.
It's like the Hatfields and McCoys, you know?
So I get up there in opening, and I had a semi-prepared opening statement. Just the bullet points that I wanted to hit. And I had printed out a poster board basically of kind of the downtown part of Orlando. And I was able to kind of take a highlighter and say, listen, this is where it started. Here's the walking up the street here. And like, this is the entirety of the interaction. And from our courtroom, you can actually look out the window and see the bus station. So I could point and say, hey, it's right here. They walked up this way. And for me, I thought it was incredibly helpful, because by closing argument, I was able to get the jury to come down to the window and look and see sort of what we've been talking about the whole time, about how close it was. But during opening,
you got to do that during closing argument. I should wait for closing argument for that part, but okay. Go ahead.
So in opening, one of the first things that I said is, we are not afraid of the facts of this case. And
it's a great line.
Yeah. The jury.
It's better than, because usually you say you're afraid of the facts of this case in your other cases. So that's nice that.
Yeah, I mean, we tell them, like, this is going to sound bad. Keep an open mind.
These are some bad facts, folks.
Yeah.
I'm not gonna lie.
So it's pretty great to walk in. And you walk in strong to say, bring it. We're not afraid of any of the facts.
Because the state brought up in opening that they were going to see a bunch of video, I brought up that, yeah, because we stipulated to it. Because we want you to have all of the video. And I said, my client agreed with the state. Let's have everything come in and let you decide, because you are the finders of fact.
I like that too. It takes the wind out of their sails. Like, we're coming in with this evidence, and you're like, yes, we asked them to.
Yeah. And it was, there was a part that I had in my sort of pre-planned statement where we were going to talk about Carla's prior interaction with this gentleman. So the state didn't motion and limb out us talking about the prior interaction. So we actually deposed Carla's mom and dad too. Not super relevant for the case, but we did it because if this argument ended up coming in, or we felt it was necessary, we wanted to kind of know what they were going to say. I had that in my notes to talk about, and I
This is
decided,
her statement that the decedent had tried to kidnap her and rape her.
yes, but
Okay.
her mom had also witnessed, like her mom picked her up from a bus stop when this supposedly happened. So we were going to bring it up in our case in chief, and I made the decision on the fly in opening statement to not even talk about it because I didn't want to commit myself to having to put on a defense to show those things. So it one of the things that, if you guys remember the Casey Anthony trial from forever ago, Jose Baez, who is a big attorney down here now,
He said
got
her dad molested her in
he got in some
opening.
stuff and then never put her
That
on
was
the
all we
stand.
ever heard about. Yeah.
Yep.
Yeah.
So what I didn't want to do is I didn't want to bring up something and then get to my case in chief and say the defense rests, and the court's like, no, no, no. This is what you talked about. We don't have that. We don't have that evidence. How are you going to get it in, Mr. Darling? And so for me, I just on the spot, like I had all the other parts checked off of my bullet points that I wanted to hit and decided not to bring it up.
Did you feel, I mean, when you were making your judgment calls, did you feel like it would be better or worse for the jury to hear that? Because on the one hand, if they hear that, it helps explain why your client wants to confront the decedent. It makes your client look more reasonable in confronting this person as opposed to someone going looking for trouble. On the other hand, it makes her look like she has far more of a motive to harm this person.
So that was exactly our concern.
Mm-hmm.
And what my thought was is going into the trial, we had fully intended to put on a case and put on that stuff with her mom and dad, with co-defendants' mom and dad being testifying, and also how co-defendants' mom and dad didn't like my client. So we had intended to put that on in our case in chief. And I thought, after I saw the state's opening and after I saw how the state sort of performed in jury selection, I made the decision not to bring it up because I felt like it was going to be confusing more so than helpful. And I still had it. I still could have brought it up had we done our case in chief. But what I didn't want to do is
Just box yourself in.
I didn't want to give the state motivation to say this is why Kai had the motive to start this altercation, which led to his death. So that was opening.
Was it the right call? We'll find out.
Yeah.
Spoiler, the show is called Another Not Guilty.
Yeah.
Okay, so go ahead. How's the evidence roll out for the people then? Who do they put up?
Yeah, so they went through and they did sort of the crime scene tech people. A lot of the evidence was, I don't want to say a waste of time, right? We're stipulating to quite a bit here.
Stuff you weren't disputing.
Yeah, we're not fighting about a lot of stuff. When the investigator comes up, and this is where co-defendant statements did come in our trial, because the state was directing the main investigator, the lead investigator, lead detective who did those interviews once the girls were arrested. And she says he was talking about my client's video statement. So, but didn't Kai say that she owned a knife? And the detective was like, yeah, she said that she owned a knife. Did she say she had it that night? She said she couldn't remember. But then what the detective says is she said she couldn't remember, but Carla said she didn't have it that night. So the investigator said that on the stand. And then I heard that, didn't say anything. I'm like, all right, door's open.
So the prosecutor is questioning the detective about your client Kai's statements, and then sort of inadvertently mentions Carla saying that Kai had a knife.
All right. Carla's saying that Kai did not have a knife.
Kai did not have a knife.
Okay. This was on direct.
Yes.
Yeah.
So you didn't violate any of the motion in limine rulings. This was the prosecutor's problem.
Yes.
Sweet.
So, and it was fortunate because
Sweet.
I had one of my associates at the time who was on the trial with me, but it just so happened the lead detective was my witness. So I prepped, I'd done all of I did the depo. I knew everything that she was going to say already anyway. So when she said this, when I got up for questioning, I was just going through sort of my process. Did you ever look at any other suspects? Did you have any other suspects? How did you identify my client? You know, all of these. She was like, and she couldn't talk about the DV arrest. So she had to say that she used AI or the algorithm that they have to identify a photo that then led to further investigation. So going through this process, and I was like, and then you said when, my client was interviewed, she said that she owned a knife but didn't have one. She's like, yes. I was like, all right. And you said when Carla said that she never had a knife that night, and she was like, yes. And states objection, and the court knew exactly where we were going, and we go up to the court, to the bench. The state is like, Your Honor, we said in the motion to limb, the court granted the motion to limb that the co-defendant statements are not to come in. Da 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 da. And he looks at me and goes, defense? I was like, Your Honor, the witness answered one of the state's questions on direct and talked about the statement. The state definitely opened the door.
Doors open.
And the judge looks back at the state and goes, state? And he goes, well, no, we kept this out in motion to limb. And he was like, overruled? Mr. Darling, please continue.
Ooh, I like it.
Okay. So we got that, and then the state wasted about half a day calling forensic
Wait,
folks.
let me ask you this. What statements of Carla did you get in because of they opened the door? Did you bring in the whole statement?
Yes.
What did you bring in?
I brought in the fact that they had gone out to eat previously, that this guy walked up to them and accosted them. We didn't bring up any of the sort of prior.
Was it important to you that you got in the fact that they were at a restaurant beforehand? Was that like a big deal to you? Like
for me,
they were on a full stomach. All right, they were actually kind of sleepy. They weren't trying to start no trouble. They had some good Southern food.
There was never a plan here.
Yeah, I like it. They were on a date. They were having dinner.
They were having a regular day.
Mm-hmm.
And this man came up to them. And so we got that out. Then he spent the last person I believe was the medical examiner, which was, I think, the most important witness in the process. But before that, he brought out some forensic folks to testify that all the fingerprints collected and all the DNA collected, none of it matched my client or the co-defendant. Which I got up one time and I was like, so you tested how many fingerprints in this case? And it was like 40 something. And I was like, all right, and how many of those matched my client back here? And he was like, none of them. I was like looking at my paper. None of them?
Did they show where they lifted the prints, like off the car? Like,
yes.
Who cares, right?
It's ridiculous. So what the state said kind of afterwards.
You should have done a motion to exclude all that bullshit, unless you just enjoyed it.
I enjoyed it. I enjoyed it because the state.
You fucking sick, sadistic.
The state's entire case was so confusing about their theory, and it was just not very coherent. And he told me afterwards that he didn't want us to get up there and argue how they didn't even really do an investigation.
Who's he?
The prosecutor.
Yeah, he didn't want me to say they didn't really do an investigation. So how could you possibly come?
You did one. It just wasn't a good one. Was that a better argument for you, Mr. Prosecutor?
It was thoroughly bad. That's what.
Yeah.
What's there to investigate? It's on video. There was an arrest. They matched AI.
So I kind of like the theory of letting the prosecutor sort of talk their way through it. When you just keep looking at the jury, like, we already told you we're not arguing this stuff. Look at all of the time that they're wasting, which is not only annoying, but they're trying to draw your attention away from the key points. They're trying to flood you with all of this other nonsensical information, non-relevant information. I think that that's a great way to make an argument to a jury.
And we were also, so one of the other things that we did is we severely limited and agreed on 4 or 5 scene and autopsy photos, so that the jury wasn't bombarded with the hundreds of photos of a dead man, either on the street or in the medical examiner's office. So there were some very limited ones, and we blocked out his genital area because some of the 2 stab wounds were near the hips in the front. So there was not a picture that showed the wound, but not his genital area. So we blocked off a part of the picture, and we did a whole bunch of things to try to make
That's nice.
As less disgusting as possible.
Well, I always also just feel bad for the decedents. No one wants to be laid out like that in front of everyone. So that's nice.
Yeah.
Give them as much dignity as you can.
Yeah, and it was
So
part of it too.
go
Is
ahead.
we were saying when the state gets up there and says, you know, defense and I have stipulated to this. Every single time he said that, I was just looking at the jury, and they would all look at me like, okay, all right.
And it's great. You did that from the beginning. You told him, look, we were going to be in agreement. So every time he said it, he made your point for you. And you got to look at the jury. Told you, we're not hiding anything. I told you without ever having to say anything, which is chef's kiss when the DA does your job for you. Thank you so much, Mr. Prosecutor.
I'm gonna use that. I think I'm next time I'm in trial. I'm gonna be like, jurors, I want you to pay close attention to every time the prosecutor says stipulation. That means we agree, and I want you to look over my direction and give me a wink.
Yeah.
All
Yeah.
right, you have to say the last part. Give me a wink.
Give me a wink, okay?
We're in this together.
Okay.
Yeah. So the best witness for us, so I mean, all of it, even the detective, like we were able to not even necessarily impeach in sort of a traditional sense, but more of just a credibility thing. Like you never looked at other people, you never thought that this could have been anything other than some cold-blooded murder. And when we got to the medical examiner, who might be my favorite person outside of my client that I interacted with in this entire trial. So when we did the depositions and during the trial, this woman is in her 60s. She's been a medical examiner for 20 years. She was a medical doctor before that, with her own practice. She is absolutely amazing at walking through. Here's what the injuries are. Here's the cause of death. Here are the particulars of, you know, the facts of this case. And in the depot,
There ain't nothing like a good medical examiner, isn't it? You know.
It's so in the depot we started, and she literally grabbed a clicker and had a drop down screen that came down in the room we were in. She grabbed a clicker and turned on a computer and went through 200 pictures. And I wasn't really directing much. So like when I first became a lawyer, I would have been like, this is my deposition. I'm asking the questions here. But like, this is a 60-something-year-old woman. Like, I'm not in charge of anything in this room. Like, she just started going, and I was asking questions in between. And one of the questions that I'd asked, and I asked her, you know, in trial as well, was, so how close was this gunshot wound? Are we talking, you know, 5 feet, 10 feet? And she's like, no, probably a couple inches. And I'm like, oh, shit, that's not good. Okay. And I was like, well, how do you know that? And she goes, well, if it was from 5 or 10 feet away, the size of the hole in the shirt would be the same size as the hole in the body. But when you're next to it, there's going to be a ripping and you know, essentially disbursement of the actual round coming out of the chamber.
Mm-hmm.
So the hole in the person is going to be much smaller than the hole that's blown into the shirt. And like just her way of explaining everything. And I was like, and this was in his back, correct? And
what about stippling? Do they have like the little bruises around the bullet entry as well?
yeah, so he didn't have any bruising on him, other than just the entry wound. And then he had some bruising in the front, so the bullet did not leave his chest. But it was, I mean, fractions of an inch from leaving his chest. So he had a huge bruise on his chest. And that was something I forgot to mention in opening. I made a big deal about, because who was right in front of his chest? My client.
Mm-hmm.
So what client is going to participate in something that puts them in the path of the bullet? Like, who would ever agree to
It's
be
a great
involved in
point.
this so-called killing? But hang on, let me get in front of him so I can be in line with the bullet.
Mm-hmm.
And one of the other
anything
things
else?
the medical
Yeah, go ahead. Anything else with the medical examiner? Go ahead.
Yeah, the medical examiner was one other part that we didn't get out at depots, but came out at trial, was the perfect cut along his sort of abdomen, right below his belly. To me, it was too perfect. And what we were able to get the medical examiner to agree to was, so he had on some like basketball shorts that he was basically using as boxers. Well, the drawstring on basketball shorts, if you're using them as boxers, that has to be tied, and it has to be tied pretty tight, because most basketball shorts.
I mean, you're trying to say the drawstring cut him?
So what I got her to say was that she couldn't rule it out because of the perfect angle of the cut. And then she also couldn't rule out that not just that cut, but the 2 stab wounds had taken place within 4 to 6 hours of his death. So one
Oh,
of the
that's
things,
huge.
yeah.
Someone
So one of
else
the-
could have stabbed him, in other
yeah,
words.
what my argument in closing was, and we'll get to the whole thing, but my argument in closing was, how do we know he wasn't stabbed prior to this event? And that's why he was so angry when he approached them to begin with, because he was in pain.
Were the stabbing wounds fatal, or were they just stab wounds?
They were just stab wounds. They
Okay.
they didn't hit anything particular.
Okay.
Yeah, I mean, they were just puncture wounds in the front.
And I think the drawstring argument is just more to the point of like we have no fucking clue how he got these wounds. Like,
it
could have been the
was
fucking drawstrings.
so the crazy
It
part
just
is
seems absolutely ridiculous.
so
Like, what was he did it? Was the drawstring just a nylon wire? Like, what are we?
so it was so perfect. Like, when we get done here, I can show you a picture. But what I'm saying is the line was so perfect, and like I've had scenarios. So I do jujitsu as well. And I've had scenarios where if you get pulled, or if you get your clothing pulled or yanked a particular way, you will have a perfect line. It can be on your neck from a collar, it can be on your arm, it can be your pant leg. So jujitsu, your pants tie. So I've seen marks, and again, the thing that you're tying in jujitsu is like much thicker than a drawstring. But it's like when I saw it, that was one of the things that I thought about, and I kind of let it go. I didn't bring it up in depots, but I was like, we're in trial. Like, I don't want this to be 2 years from now, and I didn't ask a question. I'm like, oh, I should have done that.
Lauren, we're just regular lay people. We're just regular people. But to a trained killer, boxer drawstrings are a weapon. You're just not a trained killer, okay, Lauren?
I guess so. It just seems the way you describe the wound seems like
anything's a weapon, okay? Anything can be used as a weapon. You
just go pull the drawstrings out of all of my sweatpants now.
It does look like, so like if you have exactly in sweatpants, right? If you have that drawstring, if you were to take that drawstring and like pull it back and forth, it is a cut though, like on him. So like you could see where that could cause like a burn mark, but like the actual cut, it's just the way it was done is so. It's just so, it's too perfect.
Well, I think it's ridiculous. I think it's great that you were able to get out of the coroner, that they really can't tell you how it happened, and they can't say that it could only have happened from a knife that the prosecutor wanted you to believe that Kai had, right? And you also got the coroner, which is brilliant, to talk about the timing of the wounds, because if they happened in a 4 to 6 hour window, that would certainly put them outside of the time frame where he was with your client and with Carla, which is great because you have then something that not only removes the responsibility from your client for those wounds, but it also makes the decedent look like somebody who is engaging in violent behaviors, violent enough. If he had another altercation with someone else where he got stabbed, this is definitely someone who was choking the life out of your client when she confronted him. So that's brilliant.
Yeah, and there was stuff that we knew about the decedent, prior issues of threats that he had made against other women, but none of that we could show was that our client knew at the time. So none of it was able to come in. But it was a scenario. The state eventually rested their case, and then it got bad briefly. So
okay,
my co-counsel, who was one of my associates at the time, she made a really good JOA, judgment of acquittal, argument at the end of the state's case, essentially saying that even with the light most favorable to the state, that the state hasn't proved that my client was a principal or that my client had anything to do necessarily with the actual cause of death.
It's what we call our 1118.
Yeah. So the judge.
Motion to dismiss. Motion to dismiss.
Yeah. So the judge, instead of just doing what most judges do and say, I understand in light most favorable to the state, I believe they've shown a prima facie case, JOA denied. What he does is he goes over a recitation of the facts that was incredibly coherent and very well put together and much better than the state's argument the entire time. And he goes on about a 12-minute conversation about the facts as were testified to in court. And I'm sitting there like, Jesus, like, you're just deny it. Like, just deny it. Move on. Like, what are you doing? Like, stop.
He was writing the prosecution's closing argument for them.
He was protecting his record, is what I believe he was doing. But
You
that was
made
my
the
fear.
motion, counsel. You
Yes.
made the motion. I'm supposed to put a factual basis for the appellate court. Case this is under review. I'm just doing my job thoroughly.
And like when he got midway through it, I was just like, oh, this is like,
We withdraw.
Paying attention. Yeah, like what are we doing? Like, just deny it. Like,
Yeah.
come on.
Sorry,
And then-
we didn't mean to say anything.
And at this point, we are at so
Wait, were you telling your client, like, don't worry, we got this motion to dismiss. Don't you worry. You just watch this. Go ahead,
So,
Jay. Go ahead, do it. Watch
I
this. Yeah.
explained to her, I said, the only JOA that I've ever won was coincidentally on my first trial I ever had. Like, I just got fortunate enough to win a JOA. The facts were in my favor. And I was like, listen, I said, it's going to be denied. I said, it's most likely going to be denied. I said, but, you know, we'll sit here, you know, you miss 100% of the shots you don't take. So
Yeah, and you got to protect your record. The problem is your bench officer was protecting his record as well.
And it was, it was like, there was a moment there where I was like, oh my God, if the state can just literally say exactly what the court is saying, but to the jury, when the jury's back in the room, we're in trouble. And it wasn't that anything about the facts had changed. It was just how the court was able to frame them. And then we got to a place where this is on Wednesday night. So I think this is like 4-5 o'clock on Wednesday night. So we had jury selection Monday, which that lasted the whole day. Tuesday is the state's case. Wednesday is the state's case. We get done on Wednesday, dismissed for the day. We come back Thursday morning. Now we're talking about, well, state rests their case, JOA is denied, and then defense rests their case. Bring the jury back in, defense rests. And then we talk about jury instructions that night. We go over some of the things that we'd already shared pre-trial.
Well, before we talk about that, so the state rest, judge motion dismissed, denied. You come out the next morning and the defense rests. So you didn't put on your client to testify.
No, right? So we rested that same night.
Okay, but can you tell us about the decision to not put your client up?
Yes. So for us, there was no benefit at that point to putting her up.
Even after hearing the judge's recitation of all the reasons why your client should be found guilty?
So the jury didn't hear that, so we were good.
Right.
I was confident in sort of the rapport and the relationship that I had built with the jury, and I was comfortable with the facts. I was incredibly comfortable with the facts. Like I could have talked for 2 hours and walked them through every moment of those 14 minutes. And I knew what had happened. I knew what didn't happen. And I was fine with that. And we decided not to bring up anything about Carla's parents and about this prior interaction on a bus at that point, because we didn't think the state had done a very good job. And I didn't want to give the state an opportunity to then try to call rebuttal witnesses because what would have happened is we would have called Carla's mom. She would have said, yes, this happened. They would have called the investigator, the lead investigator.
Don't muddy the waters.
Yeah, like they would have called her to say, we checked all the bus cam video we could find. We never saw this incident.
You saw a path and you stayed on it.
Yes.
You saw a way out.
That is one of the things that as I continue to grow and develop in this profession, that it's something, it's actually something I saw one of the, like the TikTok judges from Texas say something about, somebody was trying to say something at a first appearance. And he was like, stop talking. And the guy was like, and he asked him, are you losing? And the guy was like, no. So stop talking.
Mm-hmm.
And as I professionally develop and continue to grow, if I'm not losing, like, just shut up. Like,
I think the longer you do this, the less you put up and the less questions you ask. You leave it for argument and you get the hell out of there as quickly as possible.
We had a judge say it was called take a knee, right? Like in football, they intercept the ball and they're winning, and they try to run it back for a touchdown, even though they're winning, and then they fumble it, and the other team gets the ball again. It's like if you just would have taken the knee, run the clock out.
Yeah.
So then we had a pretty big fight about jury instructions, because the principal argument basically brings in Carla into our jury instructions. So, and the way that works is normally I'm going to read you part of it because it's necessary, right? So, murder second degree. To prove the crime of second degree murder, the state must prove the following three elements beyond a reasonable doubt: that the decedent is dead, right?
You stipulated to that, so check.
Yep.
There's the wink.
The death was caused by the criminal act of Kai or Carla.
Okay, and the coroner said that the knife wound, which the prosecutor had said was Kai's fault, wasn't the cause of death. It was the gunshot, which could only have come from Carla.
Yes. And then the next part, it says, there was an unlawful killing of the decedent by an act immediately dangerous to another and demonstrating a depraved mind without regard for human life. So
the unlawful act is where you have your argument.
Yes. And well, also the problem with the principal argument is that's what adds Carla's name to the second part. The death was caused by the criminal act of Kai or Carla.
It has to be Carla. In order for them to get to Kai, they have to say Carla shot him.
Mm-hmm. So what we were fighting about is essentially there's another part here where it says an issue in this case is whether Kai or Carla did not have a depraved mind without regard for human life, because either one acted in the heat of passion based on adequate provocation. It says in order to find that Kai or Carla did not have a depraved mind without regard to human life, because she acted in the heat of passion based on adequate provocation. And now there's a couple other elements. So what we were fighting about is the state wanted Carla's name in the instructions, so she would get all of the burdens of Carla's behavior. So Kai would have all the burdens of Carla's behavior. But in the part where it talks about the depraved mind and any of the other parts, they didn't want Carla's name. So what my argument
So they were trying to backdoor, you had backdoored the stand your ground during the trial, and they were trying to close that backdoor. They were trying to say, yes, we want to put in the jury instructions that Carla was the one who shot him, but we don't want them to be able to say anything in the instructions about the fact that she shot him because she was standing her ground or protecting Kai or anything else. That they were just trying to say that they wanted the instruction to say Carla was a cold-blooded killer and your client was helping her.
Yeah.
So dirty.
The big thing, the big part for me was, I mean, it had gotten so heated in the jury instructions that I told the court, I said, Your Honor, I said, at this point, I said, if the state wants my client to have all the burdens of the principal argument, but none of the benefits of also being able to say that co-defendant acted reasonably, then I think we have to open back up our case in chief, and I have more witnesses to call.
Right.
And at that point, the state, objected to that. They were like, well, the defense rested. I said, yes, Your Honor. I said, and also these changes were never in the pre-trial sample jury instructions that the state sent to us. So these are brand new as of yesterday. And the court thought about it for a little bit and said, state, listen, you're the one that charged the information this way. You're the one that charged her as a principal. You're the one that's saying she has all those same responsibilities. If she has all the same responsibilities, she gets all the same benefits that Carla's going to get in her trial. So we were able to keep them in. And then there's also an instruction that on principles that we thought was helpful. So we're fighting about these jury instructions, and the principal's argument is, and this is basically how you get to second degree murder for my client, is if the defendant helped another person or persons commit a crime, the defendant is a principal and must be treated as if she had done all the things the other person or persons did if the state proved beyond a reasonable doubt that the defendant intended the crime to occur or knew that Carla intended the crime to occur, and the defendant did some act or said something that was intended to and did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. So one of the things that I pointed out as well, prepping for closing, was my client was talking to arguing with the gentleman, getting ready to fight the gentleman. At that point, she didn't even know what Carla was doing. Carla was just kind of following like a puppy. Like Carla, she was just there. But it was one of those things that being able to keep the co-defendant's name in the jury instructions, not just in the places where it was bad for my client, but also in the places where it was good, is honestly what I think won us the trial at the end of the day.
So then ultimately the jury instructions said what?
So they had both Kai and Carla's name in all of the sections. So essentially where you would get credit for self-defense, if you believed Carla was acting in self-defense, Kai got that benefit as well, which is what we had tried to do the entire time.
This brings us right back to the beginning with the stand your ground.
Yep. And it was, the hard part for us was, I mean, we had gotten to a place where Kai had given me permission to go with Carla's lawyer to talk to Carla and explain why we wanted them to file the stand your ground. And, you know, like, obviously I'm not going to share that conversation, but she just didn't want to. And ultimately that's her choice as a defendant. I tell folks, I said, you have three choices. Okay. You either charge, if you're able to select your lawyer, right? You choose your lawyer, or if you're fortunate enough to get a public defender, you get your public defender and you ride with it, or you don't, right? Like, those are your choices. So you pick a lawyer, you choose whether to plea or go to trial, and you choose whether to testify at trial. Those are your choices. Everything else is strategic. Everything else is on me. So we got the jury instructions, and we talked a little bit before we went into the closing argument. So the way that we do it here is the court reads the jury instructions, then we do closing, and then they read the last little bit, which is just sort of, you know, sending them to deliberate. So the state was like, I'm going to need 90 minutes for closing. And I'm like, okay, that's fine. 90 minutes. And there's no scenario where the court actually holds us to any time frame, particularly not on a case like this. But the state went and he banked like 17 minutes. So what is that? An hour and 13 minutes he was talking for. I know the case better than anybody, which is something that I just absolutely pride myself on when we're going to trial. I couldn't follow him. And he skipped.
You say that was the first line of your closing.
Yeah.
I didn't follow any of that, and I know this case better than anyone.
So the state attorney and I, it had gotten kind of testy between us at a few points, because he was wholly unwilling to have a legitimate conversation about trying to resolve the case prior to. And at this point, I did not believe his version of events were provable. I didn't believe he had a good faith basis to believe he could prove this based on the facts of the case. And that's what their obligation is supposed to be. And he skipped over a particular part of jury instructions. And I'm not normally like a writer. Like, I'm not normally going to go up there and draw all over jury instructions and verdict forms and all of that. But he completely skipped what's called the independent act instruction. So, and this was kind of the other thing that we fought about getting in. And it says, if you find that the crime alleged was committed, an issue in this case is whether the crime of second-degree murder, manslaughter, or aggravated battery, because those were the lesser included, was an independent act of a person other than the defendant. So it says an independent act occurs when a person other than the defendant commits or attempts to commit a crime, one, which the defendant did not intend to occur, and in which the defendant did not participate, and which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant.
Well, I mean, you can see why the prosecutor wanted to skip over that instruction.
So part of my process is I knew which buttons to press with him that would genuinely make him mad. And when he is frustrated, he gets flustered. And not only can he not put together coherent arguments, he comes off as childish. So he does his hour and 13 minutes. And I got up there, and I tell you, I spent 7.5 years in the Army. I was deployed twice. Like, I've been in combat. I have never professionally been as locked in as I was locked in for that hour and 20 minutes. And I went through everything. And I went through the jury instructions. I went through the facts. What I started closing statement with was, everything that I told you in opening statement is exactly how this happened. I told you at the very beginning, we are not afraid of the facts of this case. We wanted you to have all the information so that you could decide what the outcome of this case should be. And I walked them through everything. And in closing, like I said, I asked for them to be able to get up and walk over to the windows and look where this took place. And the state objected, and he was like, so the state brought it up in closing that I had said in opening that they were going to have an opportunity to walk over to the windows as trying to like discredit me. It's like I had said this, and then they never went over to the windows to look.
Hold my beer. Here we
I
go.
was like, okay, fine, no problem. If that's what you want, let's get it. And the court was like, well, they can walk over to the window one at a time, but while they're doing that, you can't continue your closing argument. I'm like, okay. So I just stood there right in the middle of the court.
I feel like though that's kind of like introducing new evidence in the middle of the closing argument, though. Now you can go ahead and take a vantage point of the window from this vantage point. I mean, this is like almost 2 years later.
Mm-hmm.
Maybe some things have changed. Is it similar as to how it was when it went down?
Yeah, but
I don't know.
who
I think
really
there's some problems.
cares? That's not where he was murdered. Who really cares? It was just, I mean, this had to have been in part just to push his buttons, right? You were talking about pushing his buttons to get him flustered. Just fuck this guy, especially since he brought it up in his closing. Well, he said you were gonna. All right, fuck off then. Let's go ahead and do it. Who cares what they can see out the window? How does that change anything?
Just appellate judge. I'm just this guy. We should fucking. I think of course it's nominal, but I feel like as this.
I understand.
Appellate judge let it happen because it technically is.
You're not wrong.
So we go through that process, and I go back and I make every argument. I talk about here's all of the different reasons why you can't find my client guilty on second-degree murder. Here's all the reasons why you can't find her guilty on manslaughter. Here's all the reasons why you can't find her guilty of aggravated battery. And the state had asked me in the beginning, did I want to include a lesser in charge of misdemeanor battery? That's a maximum of a year in jail. She already had 21 months in jail. So I said, no, there's no reason, because I didn't want the jury to come back with anything saying, oh, guilty of misdemeanor battery, but credit time served, you get out today. Right? I didn't want any of that. I said, I figured I don't want to give them an excuse.
You want it all or nothing.
Yeah. And my client did too. And I went through and I crossed out second-degree murder 1, 2, 3, 4 times. I crossed out manslaughter like 4 times. I crossed out aggravated battery 2 or 3 times. And I marked on the page, we the jury find the defendant not guilty, on like my version of the verdict form, right? So
I like it.
That, and I just kind of left it on the overhead projector.
Good, I'm used to seeing that.
I continued to go through the process. One thing I do in every single case is I ask the court to move the we find the defendant not guilty above the other choices of the main charge and then the lesser included. I ask every time. Nobody's going to do it like it's a standard form, but I ask every time because I said, Your Honor, if we're coming here with a presumption of innocence,
I like the argument. Yeah,
guilty. Every judge denies it, but I'm going to keep shooting, and maybe one day I'll get it. But we went through the jury instructions, and I went through every piece of evidence. I talked a lot of trash about why were we here for an entire day on Wednesday? Why were we here for fingerprints and DNA that had nothing to do with this case?
There it is. There it is. That's what I was talking about earlier. Yeah. Yep.
And I talked about, why did you hear from crime scene investigators who only looked at a car that the fingerprints and DNA weren't relevant to the car once it got back to some garage somewhere, and they don't even work at the office anymore? Like, what are we here? Like, what are we doing? And I just kept hitting on the fact that we are not scared of the facts of this case. And I said, there's nothing here, certainly not beyond a reasonable doubt. I said, there's nothing here to get you to a place that on these jury instructions allows you to find my client guilty. And then when the state got back up, so I had a couple of my other staff members were there, and then the co-defendant's lawyer was there for a good part of the third day.
That was smart.
And closing.
On their behalf, that was smart.
Yeah. I was like, listen, first, you need to come and watch, because I want you to be in a position to be successful when this is over. But when I went to sit down, like, I felt like I did a good job in closing, but I didn't understand until like later, like how persuasive I'd been. And the state got up, I kid you not, like a petulant child, and was talking to the jury. You have to find second degree. Da 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 da. He took his version of the jury verdict form, set it on top of mine, X'd on must find her guilty of second degree murder, and then he like signed and dated it as if he was like the foreperson on the jury form. And it was just so like petulant. It was
Yeah.
and that's exactly what it was. And I was
Mm-hmm.
sitting there and I was just like, okay, what are we doing? And in his rebuttal, there were 2 or 3 times where I objected. And what I was saying is I was like, objecting, those are facts not in evidence. And the first one the court overruled because he was talking about something. And he brought up one other point. And I don't remember exactly what it was now, but I objected as facts not in evidence. I said, and we approached, and I was like, Your Honor, I was like, that's never been brought in evidence. And he's like, state? And the state's like, but that's what it shows. And I'm like, and the judge is like, yeah, we're going to sustain that one. And I was like, move to strike. Like, let's go ahead and take that off the record completely. And then this is like, members of the jury, you're going to please strike the last thing he said. So in his remaining 13 minutes or whatever it was, he only was up 6 or 7 minutes, but I objected probably 5 or 6 times. And it was an objection in a manner like, oh, really?
He was just spiraling out.
And it was like, I am a nervous wreck when the jury goes out to deliberate. Like I feel like I have all the same weight as my client and none of the consequences. Like it's
An accurate way to sum up what it feels like as the defense attorney.
And we ended up, leaving, and I have here exactly. It was like 2 hours and 20 minutes, 29 minutes, something like that. And we have a verdict. And it's, 4 something in the afternoon. I'm like, all right, like let's, here we go.
On Thursday or Friday?
Thursday. So we didn't even get to the Friday. Okay. So we come back in the courtroom, and the first thing is normally when a verdict is read, there's a bunch of other deputies in the court. And it's not because anybody knows what the verdict is. It's just safety precautions, whatever. You don't know who else is in the courtroom. So one of the things that I asked is, generally when the verdict is read, if a client is in custody, they actually have them handcuffed and fully shackled, whereas during the trial, only her legs were shackled, and she's behind the table, so the jury never sees that she's shackled. I mean, they knew, because I talked to a couple of them afterwards, and they knew she was shackled.
Underneath the table, she's shackled?
Only her feet.
During her jury trial?
Yes.
Oh,
only her feet are shackled, but her hands are free to move around. But normally, once the verdict is in, but they haven't announced it yet, normally they come and they shackle her arms to her feet in the same way you would be shackled moving throughout the jail. So what we did is I did just an ora tenens motion to the court. I said, Your Honor, I said, understanding that, court personnel have their security priorities and whatnot. I said, Ms. Watson has been here for her trial the entire week. She has never once been a problem. She's never raised her voice. She's never stepped out of line. Your Honor, I would like to ask that she not be shackled. And I have a pretty good relationship with most of the deputies. They are, I think some of them know that I ran for sheriff, and they're like, oh, okay, good job, puncher's chance, right? Like, maybe you could have done something. But a lot of them know me as an attorney, and like, I don't hide the ball, right? Like if we have a good case, I know we have a good case. If we don't, I know that as well, right? Like I know the bad facts, but I also know the good ones. And it's one of those things that I was able to convince the supervisor to allow her to just stay there unshackled. And like my client's sister's in the courtroom, the co-defendants, like auntie is in the courtroom. Like there were a few people there. So the jury comes in, and when they leave, they actually have 2 sheets. So the first sheet is the standard verdict form that has second-degree murder, manslaughter, aggravated battery, or not guilty. If you found guilty for second-degree murder, there's also an additional firearm jury instruction where did you find that this person had in the commission, used, possessed, provided a firearm. So when they came back in, I knew the verdict 45 seconds before everybody else.
They had 1 sheet.
They had 1 sheet of paper. And I was sitting there like, I knew it wasn't aggravated battery. I beat that one up. I knew it wasn't manslaughter. And when I saw 1 sheet of paper, I was like, oh my gosh, did I really do that? Like, did we really do that together? And they came back. The court read it, stone faced, no indications. And then they let the clerk publish the verdict.
Wow. And it's not guilty, right? So how
And
did your
it
client
was
react?
not guilty as to everything. So my
How long
client
had your client been detained for at that point?
652 days. So a little bit
Wow.
more than 21 months. So the verdict came back a little bit before 5:00 p.m. She immediately started crying, gave me a hug. I started crying. So like not like boohoo crying, but like I need to breathe. Like this is like I was like tearing up and everything because like you don't get a lot of I told you so moments on that serious of a case in this profession. And it was one of the things where the state literally refused to negotiate with me to try to get this resolved, to try to make everybody else's life just get this going. Like let's get this closed and move on. But he refused. And at that point the court asked, does anybody want to poll the jury? He didn't. And I went back and looked at the trial transcripts and I said, "No, Your Honor." I don't remember saying anything at that point. Like I was in my own little world. And I know I was teary-eyed. I know once she started crying and I was definitely teary-eyed. Some of the jurors started crying. It was a phenomenal moment. And it's something that, I'll never forget. By the time we left the courthouse, probably 5:30, 5:45, when I was going out to my car, two of the jurors were in the parking garage. And I drove by coming down and they kind of waved me down real quick. And I talked to him very briefly. I was like, what did you guys think? And he goes, it didn't make sense. Like, how are you responsible for what somebody else does? And so like the whole thing, and they told me like the fact that I came out from the very beginning, explained what was going to happen. It's exactly what I said was going to happen. And I told them from the get-go, I wasn't afraid of the facts. They said that mattered to everybody on that jury.
It's so important as a defense attorney to build credibility and maintain it with the jurors. It's so important.
Yeah, one of the jurors kind of joked. He goes, there was a moment where he said he was trying to follow what the state was saying when he was doing his direct of one of his witnesses. He said he couldn't figure out what the state was doing. He looked at me and I looked confused, is what he told me. Yeah. And no, it was phenomenal. I got home at probably 7:00. I tried to bring all my stuff back to the office and just kind of sit for a minute by myself. I got home and then about 9:30 that night, back on August 22nd, my client's sister FaceTimed me and she was in the
all right,
in the car with her. So
great. Can you tell us how Carla's trial went down?
Yeah, so actually, last week she pled to 10 years.
10 years? Okay.
On a manslaughter or something?
Yeah, I believe it was amended to a manslaughter. She pled to 10 years. She has credit for a little over 2 at this point.
Interesting that she didn't go to trial saying that it was...
They had eventually at some point filed the stand your ground, but they never actually went to the hearing. So it was tough. I think that when we won the trial, that would have been the time for co-defendant to really kind of mash the gas and try to get in the courtroom as quickly as possible.
Yeah.
But by kind of delaying and taking more time and then the holidays and all of that, it just wasn't. And my client also, because I asked my client, would she be okay if I helped, the Carla's attorney on Carla's case? And she said straight up, like, I don't want anything to do with her. Rightfully so. And because of that, my ethical obligation is still to my client. So if my client doesn't want me helping or being helpful, I'm not going to be. And I completely understand. I get it. But it's one of those things that she just didn't want to make a decision. And one thing I did not bring up that is an interesting fact is co-defendant at the time was 17 years old.
Oh no! I wish you wouldn't have told me that. That just makes me sad.
So
Oh,
it's my client was 21, I think. It was not. It's a young
Yeah.
person. So
minor living in a van with mental health issues. Oh no. 10 years for a
10
minor?
years.
Fucking Florida.
They direct filed on her.
Fucking Florida.
That's so. There's a weird side story about how our elected state attorney was removed in August of 2023 by our head elected official down here, who is a character.
Talk about your governor.
Yeah,
Don't say Ron.
he's a piece of work. And work
Some people say
harassment
don't say
continues.
gay. We say don't say Ron.
But it was a process. But at the end of the day, when the jury came back with the not guilty, obviously it changed my client's life. It was probably at the time it was the hardest thing I'd ever done professionally. We had a situation here recently with a juvenile that got into a car accident and 4 people died. There was a plea hearing for that was probably more difficult emotionally. But at that point, I mean, a murder trial, I'd only been a lawyer for 5 years at the time. And, the family trusted me, my client trusted me. And that relationship, like I still talk to Kai about every 2-3 weeks. So it's
And that's what you get when you get a private attorney.
yeah.
There it is.
We had a great relationship when she got out. She was able to get a job working for basically like a pest control company. Doing some office work, and then I think she's getting to a place where she's going to be doing some of the actual pest control. But we we did the work. We got the right outcome, and I could not be happier for her and for her family.
Cool. Great. Well, great job, Andrew. Thanks for coming on the podcast. Thanks for sharing your story. Let's close it out with the last question we always ask our guests. What led you to this work? Why did you become a public defender, and why are you still a defense attorney?
So I grew up in a pretty rough part of Orlando, and I tell people every day I'm just an Oak Ridge kid. So Oak Ridge is the high school I graduated from, and it's part of what I think shaped me as a young person. So I saw a lot of my friends lose big chunks of their lives. Some of them are still in custody now to the criminal justice system. And what I thought at the time was not having great attorneys. And when I was done with the military and decided at some point, hey, let's give this law school thing a try, there was never a question in my mind I was going to be a defense attorney. I've only wanted 2 jobs in my entire life. I wanted to be a public defender in Orange County, and I wanted to be the head football coach at my alma mater. So I've had a chance to do one of those. I've been a high school head football coach before, but just not at my alma mater. So it may be something that gives me that opportunity in the future. But being a criminal defense attorney, I mean, we have a couple other things that we can do here, personal injury and whatnot. I hate all that stuff. I really do. Like we do it because some of our clients have those needs as well, but I love being a criminal defense attorney. It is my favorite thing. Like you never have the same day. It's always something different. You meet my favorite people that you meet. Some of our clients are some of the absolute best people in the world who are struggling through situations that some of us will never understand and will never have to go through. But they're showing up every day and they're fighting for themselves. And damn it, they deserve us to be there to do the same thing. And I
Word.
can't see myself, I can't see myself practicing any other area of law. I don't care how big or small my firm gets. We're a criminal defense firm. Like that's what we do. And I love it. Some of my clients have become, friends. Some of them almost sometimes feel closer than friends because they are they're just a huge part of my life, and they've had such an impact on me that I wish everybody out there in the sort of general public had the opportunity to see these folks as people the same way that we get to. And there's nothing better than having a verdict come back in your favor. And those 2-word verdicts, those are the best.
Not guilty. Sorry, I'm just thinking about an Instagram post I made. Not guilty.
And another one.
Yeah. Great. Well, thanks for being on the show, Andrew and Lauren. Great seeing you again. I'm glad we got to hang out.
Yeah, finally.
Yeah.
Stay safe out there.
All right, guys, and hopefully by the time this gets out there and the rest of the ANG verse can hear this, we will no longer be
Occupied?
or recording from the bunkers or anything like that. So
we love you, LA.
Wish us luck, everybody.
Yeah.
All right, until next time, take it easy, guys. Bye.
There's not a good way for me to explain it.
All right, well let's see these deadly drawstrings.
Oh, here's actually a good one. So this is, you can kind of see like ants because he had been there for a little bit. But like, look at that wound.
Oh yeah, I mean, it's very, for that to be a knife to go across with such straight lines. I mean,
that's what the argument is.
I see what you're talking about.
Yeah. So that place where that big pile of ants are is where one of the stab wounds is, because the actual, like, when you get stabbed, and I only know this because I was in the army, but if you get stabbed and you're eventually cleaned up, like, your body fat is going to protrude from that wound. So it's here, I can show you guys sort of a better